You are watching PR English Shorthand Dictations YouTube channel.
This is English shorthand dictation number 409 and the dictation speed is 120 words per minute. Ready? Start. We have heard the Learned Counsel in support of the appeal and the Additional Solicitor General for the respondent. The submission of the appellant is that in concluding that the deceased was not traveling in the train on 5th September 2003, both the High Court and the Tribunal have overlooked the findings contained in the final report dated 6th November 2023, submitted by the investigating officer to the subdivisional magistrate. According to the submission, the above report also includes an extract from the post mortem report, which indicated that the cause of death was due to head injuries resulting from a blunt force impact. The estimated time of death was determined to be between 48 and 72 hours before the conduct of the postmortem. In support of the claim that compensation ought to be awarded to the appellant, the Learned Counsel submitted that it is not necessary to produce a valid ticket to claim compensation under Section 124A of the Railways Act 1989 in view of the decision in Union of India versus Reena Devi. The law laid down by this court in successive decisions has clarified the test by which the amount of compensation under the Railways Act must be computed, including the entitlement of the claimant in case of an increase in the permissible amount. He submitted that the appellant should be awarded interest as admissible in law. In response, the respondent argued that the appellant had not provided a reason for the delay in the discovery of the body of the deceased. It argued that other employees of the railways were bound to have chanced upon the body in the days after the alleged date of death. It supported the judgments of the tribunal and the High Court. Written submissions have been submitted on behalf of the appellant as well as the respondent. Before turning to the issue at hand, it is necessary to briefly advert to the judgments of the tribunal and the High Court. The tribunal framed three important issues for consideration. First issue was whether the deceased was a bona fide passenger of the train in question on the date of incident. Second issue was whether the incident as alleged in the claim application took place and was covered within the definition of an untoward incident under section 123C of the Railways Act. Third issue was whether the appellant was entitled to compensation and what the relief should be, if any. The appellant deposed in support of the claim together with her cousin Deepak. Both witnesses were cross examined. The railways did not produce either oral or documentary evidence. After considering the material on record and hearing the parties, the tribunal found that no ticket was found with the deceased, whose body was found on 8th September 2003. Neither the appellant nor her cousin was eyewitness to the death. There was nothing else on record to show that the deceased boarded the train. The tribunal also found that the appellant was required to produce the best evidence but did not do so. The report of the investigating officer was not sufficient to rebut the presumption under Section 191 of the Railways Act. The tribunal concluded that there was no evidence to prove that the deceased died as a consequence of falling off the train. It found that compensation was therefore not payable to the appellant. It later dismissed the application for review of its judgment on the ground that no new facts were placed on record which would warrant a review. The tribunal also observed that the secret witnesses examined by the investigating officer were not examined. On appeal, the High Court dismissed the appeal against the decision of the tribunal. By its judgment dated 7th January 2014, the High Court held that from the material available on record, it appeared that the body of the deceased was found lying near the railway track. However, nothing on record indicated that the deceased was traveling as a passenger on the train. The post-mortem report indicated that the death took place between 48 and 72 hours before the conduct of the post-mortem, which was on 9th September 2003 at 1:30 p.m. From this, it cannot conclusively be held that the deceased died on 5th September 2003. The court held that the report filed by the investigating officer is not supported by substantive material. Since he had no personal knowledge regarding the cause of death, his report cannot be accepted as evidence of the fact that the deceased was traveling as a passenger on the train in question. The court therefore concluded that the appellant failed to establish that the deceased was traveling as a passenger on 5th September 2003 on the train in question. The High Court later dismissed the review petition preferred by the appellant. It held that the material facts as well as the questions of law had been considered in the judgment under review, and the report of the investigating officer was based on a secret inquiry conducted by him. The investigating officer did not disclose the material facts which led him to conclude that the deceased was traveling in the train. Further, he was not examined. The opinion of the investigating officer, as recorded in his report, was therefore not substantiated. Therefore, the High Court concluded that the appellant had not made out a case that there was an error apparent on the face of the record. From the recapitulation of the various judicial pronouncements leading to the present appeal, it can be seen that the primary issue is whether the deceased was traveling on the train in question. In Union of India versus Reena Devi, a two-judge bench of this court considered the question of the party on which the burden of proof will lie in cases where the body of the deceased is found on railway premises. This court held that the initial burden would be on the claimant, which could be discharged by filing an affidavit of the relevant facts. Once the claimant did so, the burden would then shift to the railways. Significantly, it also held that the mere absence of a ticket would not negate the claim that the deceased was a bona fide passenger. In the present case, the appellant had duly filed an affidavit stating the facts and adverting to the report arising from the investigation conducted by the respondent, which showed that the deceased was traveling on the train and that his death was caused by a fall during the course of his travel. The burden of proof then shifted to the railways, which has not discharged its burden. Therefore, the presumption that the deceased was a bona fide passenger on the train in question was not rebutted. Further, the report of the investigating officer indicates the details mentioned in the post-mortem report. It states that the cause of death was due to an injury sustained on the head and that all injuries were ante-mortem and caused by blunt force impact. It also states that 48 to 72 hours had passed since the time of death.